Hello everybody, David Traylor of the Traylor Law Firm. I'm up here at the Frank Crowley Courthouse at the top of the parking garage waiting in my car because there's a judge that I need to see and she's not done with her trial yet. So it's probably going to be an hour before she's done with her trial, and then I'll be able to go in there and handle my business. But until then, I want to come up here and make a little video for y'all about something very useful, which is how cases proceed through the criminal justice system. You can see the Dallas skyline back here. I wonder if I can zoom now. I can't zoom in or out on this mode. That's the Dallas skyline. Here's the view, the wall of the parking garage. But let's talk about how cases proceed through the criminal justice system. So there's a difference in how felonies and misdemeanors proceed through the justice system, because felonies have kind of what's I consider a safeguard procedure against direct filing. So misdemeanors get directly filed from the police agency to the district attorney's office, and then they go into a court and that case gets going. But felonies can't do that. Felonies have to first go through a grand jury. The grand jury is a panel of 13 citizens, 12 citizens, I think 13 is a backup. Anyway, just ordinary citizens. They're appointed to serve. Most of them are not lawyers, and they will evaluate cases that come before them kind of pretty quickly, usually, to see if there's probable cause to feel that an offense was committed and that the case should go on to court. So if they feel that there's probable cause, they will true bill the case, and if they feel there's not, they will no bill the case. Now sometimes they'll no bill a case for other reasons, and you know, that's one of the things that we do is we'll put information before the grand jury to try to get them no bill cases on occasion. We've got a real good track record of getting them to do that when we try. Now that doesn't mean we try on every case, because certainly I don't want to waste my time trying to get a no bill out of a grand jury that there's no way in Hades, to use the term, alternative term for the underworld. There's no way that they'll no bill certain cases. Most cases are just going to go straight through, and if you don't do anything, they'll generally get stamped on, you know, and go to court. But they do no bill some cases on their own, and it's a small minority of cases that they have put before them that get no billed. But when we go after a case in grand jury, we've got a good kind of track record of getting them no billed, and that's because when we do that, we usually have a really good reason for asking for them to no bill a case. So that's what happens with felonies. And felonies, so felonies get delayed getting to court for that very reason. It takes a while for them to put those things before the grand jury and get it resolved with the grand jury, and they handle bond cases after slower than, I should say, than people who are in jail waiting for trial. So they'll do the people still in custody quicker than they'll do the bond cases. So you know, I like to put this process in terms of decision makers. At any phase of a case, there's always someone who's got the decision-making authority over those cases. So you might think that the judge is always the one who has that authority, but that's not true. If you think about how cases are generated, you can start to understand this. So the first person who has decision-making authority over a case and whether it's filed or not is the person who first conceives of the idea that there might be a criminal offense. So that can be a victim, a crime victim. That can be, and we call them complaining witnesses around here, because criminal defense attorneys don't like calling them victims. We like calling them complaining witnesses, because that's truly what they are. They're complaining of something that they consider an offense. But that can be one person who can do that, and then it can be a bystander or a witness, someone who thinks they've witnessed a crime or think a crime may be occurring, that calls police or flags a police officer down. And then it can also be a police officer who thinks that they've observed an offense. So that's the first person who has decision-making authority over a potential offense. And so if that person either decides not to proceed, like decides not to call 911, or decides not to try to seek criminal charges, then that case never really gets going. So they're the first person with decision-making authority. Then the police get on the scene. Sometimes they're the first person, but sometimes they're the second decision-making person on scene, because they've been called to the scene, and they respond and they decide whether they think a case should be filed. And to give you some examples of this, let me give you an example where the police just think they've observed an offense. Speeding, any traffic violations are like that. The officer is the first person who thinks there might have been a crime that occurred, and they can come to your window and say, hey, slow down. We're not going to give you a ticket right now, and just go on about your business. So they can decide not to pursue criminal charges. Speeding, traffic violations are low-grade criminal charges. The other thing that could happen is you could be kind of a golden-tongued, silver-tongued person who has the kind of gift of being able to talk your way out of situations. This is something that I've done many times when I get pulled over. I have some advantages in that I've been to law school and that I know a lot of police officers and people in the justice system. So, one of the ways that you can get a police officer off your back on a traffic ticket is to establish some sort of common ground so that they, it can be lots of different things. It can be professional courtesy sometimes works. Even if we're on the opposite side of things, that sometimes works. So they can be persuaded to not pursue a criminal charge, to give a warning instead of a ticket. And it's kind of a Better Call Saul situation where he comes to the rescue with his mouth and just talks his way out of situations. That's something that can be done on occasion. Now, most criminal cases, the lawyer that gets contacted eventually isn't going to have the opportunity to do that because the contact comes after a charge has already been filed. Even if I've had clients call me when the police are on the scene, and sometimes the officers will let me talk to them and sometimes they won't. That can be the difference between a charge getting filed or not. But a lot of times that opportunity is already gone and the case is already put into the pipeline of the criminal justice system. So then where does that case go? Who has the next decision-making authority over the case? Well, typically that's going to be a prosecutor. There's intake prosecutors, there's grand jury prosecutors, and then like we discussed, there's the grand jury. So the prosecutor will do the intake. They might decide not to prosecute the case. They might decide to prosecute. Another example of that decision-making comes when, in recent years, we've had the DA's office deciding not to prosecute low-level misdemeanor marijuana possession cases, especially where no one has a criminal record. So, even though the police agency puts that file into the pipeline, the DA decides not to prosecute. So they have the prosecuting authority at that point. Now, I'm telling you all this to kind of give you an idea that this is one of those things, this whole kind of packet of information is stuff that you may know most of it, you may not. It depends on your level of involvement with the criminal justice system, your level of sophistication in these matters, just kind of your level of interest, your level of exposure. And so, if you do contracts or real estate, you may know none of this. And so this might be something that teaches you a great deal of information about how cases process through the system. You may be someone who's been through these cases yourself as a defendant many times and know most of the stuff. But even then, you might not know a lot of it because you kind of have spotty information about what's going on as your case proceeds through. You may think you know how this works, but you might not know all the details. So whatever level of information you get out of this, I hope it's helpful. So when it comes to decision-making authority, you've got prosecutors, and they can, it's about when I get involved. So we've got your level of knowledge on this, and it's important for you to kind of have a comfort level, at least if you're going through this. And a lot of people who will be watching this video have come here because they have some sort of criminal trouble that's cropped up in their life, and they want to know what to do about it. They're trying to find an attorney, and maybe this will help you understand the process better. But it's critical for your attorney to understand this process on a much, much higher level. And one reason it's critical is because the decision-making people, it's important to know where to apply the influence, the pressure, the negotiation, the information, the persuasion. And it's also important to know when you have to move on to the next phase and stop dealing with the person who has already lost their authority to decide on this case. So like once a case leaves the detective's hands and goes to the DA's office, or when it's lost, when it's left the police officer's hands and they've filed their report and it goes on to the DA's office. A lot of times they've lost their decision-making authority on these cases to let them go. But there are times when you can go back and try to get their influence on it. There's also times when you can go back to the complaining witness and try to get their influence to have a case discharged, dismissed, dropped. But it's important to know when those opportunities are available and when they've been lost. I'll give you some examples of that. A complaining witness has a lot of authority to say what they want to happen with a case, especially in something like a theft or a property damage case. But when it comes to family violence cases, domestic violence, when the police get called out to one of those scenes, they're going to arrest somebody just as a matter of policy, because they want to make sure that they don't leave a scene where both parties that are, two or more parties are there that have had their flare up, and that when they leave, even though it looks like everything's calm for the moment, it flares up again and someone either gets badly injured or killed. So they arrest people on those, and you can't call the police out to the scene and reasonably expect that you're going to talk them out of arresting the other person or you. And they might arrest you even if you made the call. So you can't expect to talk your way out of that one or exercise your decision-making authority as a complaining witness on that kind of case. However, if someone busted your door down and y'all patch it up and decide that, you know, he's giving you $200 to fix the door and you don't want to have charges pressed, usually you can get the police to go away on that and everybody's happy. You know, no charges get filed. On a family violence case, like I said, it's important to know when you can revisit the person who may have ultimately, in the beginning, had the decision-making authority. They may have decided not to call the police, but then they call the police, they lose that authority. It's important to know when you can go back to that person and say, hey, do you still want to proceed? Do you want to drop these charges? And kind of help them get the charges dismissed if that's what they want. And that's not an easy process. It's certainly not as easy as it once was. It takes some doing, it takes some finesse, and but it's important to know when it's still possible. Same thing with officers. It's important to know when you might be able to get an officer to let go of a case, or even have the district attorney go back and have another conversation with the officer and see if they're willing to let it go. And complaining witnesses in any case, sometimes they cool down and they don't want the blood or the punishment or the custody that they once wanted out of a case, and there can be options there to get cases moved in your client's favor. So you've got the prosecutor dealing with the case from the point that it gets to them, into their court, and all the way up to trial. And then you got to think about how the judge is going to come into the picture, and when their influence starts to be felt or needed or used. And a lot of times that can come at pretrial motions to suppress evidence, motions to quash, all sorts of pretrial evidentiary matters or other pretrial matters. Then the judge's influence can come into play, and you can sometimes leverage the possibility of the judge's intervention with the prosecutor to get better outcome before you have the judge decide matters. So, but then it comes time to decide whether the case needs to go to trial. If you're not getting an outcome that's acceptable from the prosecutor, then you've got to decide whether you want to have the decision-making authority turned over to a judge or a jury. And sometimes that's the plan from the very beginning. Other times it's the last option after all other avenues have been pursued. And but then they are the ones that you have to bring negotiation powers, leverage, storytelling, congeniality, professionalism, all these things. You have to bring those to bear on them to try to influence their decisions and get a decision in your client's favor. So I guess that's kind of a short synopsis of the process through the justice system, and who I think I always like to think of it in terms of who's got the decision-making power on a case. There's certainly a lot more detail that goes into this, and I haven't talked a whole lot about court dates and appearances and that sort of thing. But obviously, when you're on bond for a criminal case or you're in jail awaiting the decision on a criminal case, that case is hanging over you until it's complete. And if you're on bond, you're going to have to make court appearances as required by the court. And we try to shield our clients from having to go to court as much as possible. And certainly the pandemic has helped with that, because the courthouses don't want people in the courthouse unless they need them there. So a lot of appearances have been forgiven on these cases where they otherwise would have been required. So, but as with anything that's complex in life, it's best to have someone who really knows that stuff backwards and forwards, helping guide you through. And for a criminal case in particular, it's imperative to have a lawyer. Whether you get a court-appointed lawyer or you hire one, there are people who wouldn't dare trust their matter to a court-appointed lawyer. And generally those are people who can afford to hire counsel. So there are pitfalls with having court-appointed attorneys. Not all of them are the same, and you don't really know which kind you're getting when you get appointed a lawyer. At least when you select one on your own, you can shop. You can shop on price if that's what you want to do. You can shop on quality. You can shop on service. You can shop on results. We're going to compete on everything but price pretty well. But on price, we're not going to be the cheapest lawyers. But, you get what you pay for in many areas of life, and I think that this is one of those areas that you get what you pay for. So with all that said, hopefully that helps you understand the way cases processed through the criminal justice system. And if you have any questions, you can always make a comment below with that question. You can call us at any time. We'd be happy to talk to people about this subject or any subject that we have videos on. So it's only a free country if you're not in jail. If you get questions, suspected, arrested, seized, searched, if you feel like you're being followed, or you got a court date or out on bond, or you're just worried about some of these issues, give us a call and we'll see what we can do to help you. And everybody take care. Enjoy this beautiful weather and the wonderful week that we have and the new year. Still new. 2022. Take care.